Here at Bethel Law, we hear a lot of various estate planning myths and misconceptions from our clients as they come in through the door. Some of the most common ones are that probate is always required, or that any type of trust you have, no matter what, provides some type of asset protection. But one of the most common myths that has essentially lasted the test of time has been the $1 inheritance myth. Now, there are a couple different forms that this one seems to take, but most commonly, the idea is that you, as the parent, cannot disinherit one of your children. So in order to get around that requirement, you leave them an inheritance of $1. Sometimes it's up to $100, but oftentimes it's $1. Seems like a good way to maybe kind of get around a requirement that you have to leave your children something. Unfortunately, this only creates a lot more problems later on, which we'll get into later in the video here. Before we get into the issues with the $1 inheritance, I did want to discuss disinheriting someone in general. So firstly, there are a lot of different reasons why you might want to disinherit someone. Not all of them are bad. In fact, sometimes it's actually more beneficial to disinherit someone, which might sound a little counterintuitive, but again, I'll discuss that a little bit later in the video. Firstly, I do want to talk about who you need to disinherit. Under the California Probate Code, which is very similar to many of the other probate codes for the other states here in the US, if you do not have a distribution plan laid out either through a will or a trust, the probate code does lay out who your heirs are and how much everyone is going to receive. It does also have these individuals listed in priority and is a pretty common sense way to go about it. Your children each receive a portion of your estate. So for instance, if you have 2 children, each gets 50%. Now this goes on to what if one of your children were to pass away? Do they have children? And kind of goes down that line. If you don't have any children, then the probate code says, all right, we're going to go up to your parents and see if they're alive. Then if they have any other children, i.e. your siblings. So that is to say, typically, when you're going to disinherit someone, you're going to be looking at those in your direct bloodline, your children, your grandchildren, and so on. Next, I wanted to discuss how you go about disinheriting someone. So the whole topic of the video is the $1 disinheritance, as we call it, a way to get around having to give somebody an inheritance. But really, you can disinherit children without leaving them anything, but there is a certain way that you should go about doing so. So how do you do that? If you do plan on disinheriting someone, you should do so in writing. If you don't have a writing, the California Probate Code, as I mentioned, is going to step in and provide how your distribution is going to be laid out. So to disinherit someone, you need to have it in writing, and you should acknowledge that person specifically and say that you are intentionally not leaving them anything in your inheritance, or in your will or your trust. The act of acknowledging that person makes your intent clear that you are intending for that person not to receive anything. And again, you don't even have to leave them a single dollar. You can just say they are disinherited. I wanted to discuss why you would end up disinheriting someone in the first place. As I mentioned before, there are many various reasons why you might want to disinherit somebody, and not all of them are bad. But firstly, the most common ones we do hear are the bad ones, the black sheep. These are children or grandchildren that are no longer in the picture, as in they don't want to be around the family. Maybe they have some drug problems or even financial troubles. Sometimes this coincides with legal problems they have as well. Are they behind on taxes to the government? Do they have outstanding child support or alimony? Things like that are going to skim off the top of any inheritance they might get, and you're essentially giving your estate to somebody else because you're child ran into some problems. Another common reason we do disinherit children on behalf of our clients is if the parents want to leave something to charity, or oftentimes grandchildren. Sometimes the parents come in and they say, you know what, my kids, they've done pretty well during their lives. They've built up a really good little nest egg there, but I want to make sure my grandchildren are taken care of. Now, I know my kids are going to take care of them, but they're doing well. I want to leave something directly to those grandkids. So that's actually a pretty common practice. Grandparents will come in, they'll leave something straight for the grandchildren and skip over their kids. So in that situation, we do still have to specifically acknowledge those kids and say that you have provided for them during their lifetime. This coincides with what if you wanted to leave something to charity through your will or trust. We actually had a trust administration just a couple years ago where a lady did regularly make charitable contributions during her lifetime and even provided charitable contributions at her death through her trust. And coincided that charitable contribution with distributions to grandchildren and nieces and nephews, totally skipping over her kids, but that was intentional. The kids have done well. Now she wants to take care of the grandchildren. Finally, one of the most common reasons we see somebody need to be disinherited is when doing so would actually provide them a benefit. And again, sounds kind of counterintuitive. How am I benefiting them? By intentionally not leaving them anything. Now this crops up in situations where you have someone you want to take care of, but they're on some type of public benefit like SSI or disability. This often is due to the person having some type of disability, whether it be something, for example, autism or any other type of special needs, or they might be physically disabled. Some accident occurred and now their ability to work and provide for themselves is severely limited. So they do need those public benefits in order to be taken care of. Now your worry is, well, if I'm not around anymore to help them out, I want to leave some of my estate to them so they can be taken care of. How do I do that? If they have public benefit, they're just going to be kicked off. For example, SSI, simply being entitled to an inheritance, is enough to have you booted off the program until you use up all that money. Now what that entitlement looks like is, for instance, I'm disabled, I'm on SSI, and my parents leave me money. They pass away, and the trust says distribute to me. Now, before I've even received a cent from their trust, in SSI's view, I am now entitled to an inheritance and I am kicked off the program. I can't disclaim, say, no, I don't want that inheritance, please don't send me anything, because as far as SSI is concerned, it's too late. You're entitled to it, so you do have access to those funds, kicked off the public benefit. So a way we kind of circumvent these very strict rules while still providing for somebody is through what's called testamentary trusts. Now, a testamentary trust is something that can be established either in a will or in a trust. Now, I'm throwing a lot of words at you and you're saying, what is a testamentary trust as opposed to a regular trust, and how do I set that up in a will or a trust? So a testamentary trust, in essence, is a trust that does not come into existence until some act or event has taken place, typically your passing. So what that looks like is, if I want to provide for my son who is disabled and on some type of public benefit, I set up a testamentary trust. I disinherit my son, but I set that testamentary trust to receive what his inheritance would be. Now that testamentary trust is supposed to operate on behalf of my son. So it pays for various expenses he might have that maybe aren't covered by public benefit, or that public benefit may not mind that you're receiving outside funds in order to pay for. The most common version this kind of testamentary trust takes is what's called a special needs trust. So essentially, I leave money to the special needs trust rather than my son. The special needs trust operates for the benefit of my son. A third party is the manager, and now my son doesn't have access to those funds, even though they are to be used for his benefit. And then he is no longer disqualified for public benefits. So taking care of those that may have various special needs is an extremely common way or extremely common reason that we ultimately may disinherit a child. Finally, I wanted to touch on something I referenced at the beginning of the video. Leaving somebody an inheritance, even if it is $1, can actually just create bigger complications and bigger headaches for your successor trustee later on. Now, your successor trustee is the person who's going to step in at your death and administer your assets through your trust. The successor trustee does have various duties they do need to perform, and they do have obligations to the beneficiaries of that trust. Coinciding with that, those beneficiaries have rights. The main one that we're going to be worried about here, or excuse me, there's two of them, is going to be the right to receive notice and the right to an accounting. If somebody is a beneficiary of a trust, they are entitled to an accounting of all of the trust assets, no matter how much they actually receive, and they are entitled to receive notice on the various actions taken by the successor trustee. Now that sounds well and good. If, for instance, I'm going to receive 1/3 of a trust estate, I would like to kind of know what is going on in that trust. If I'm only receiving $1, I have just as much right to know what is going on with the entirety of that trust estate as if I was receiving 90% of it. So if someone does receive that $1 inheritance, it often inflames some bad feelings and might give them a little bit of an incentive to just cause havoc, because why not? They're only getting $1 out of the trust, and now they have an open door to inspect everything. So that does create a big issue or a big complication and really a big headache for your successor trustee trying to administer your assets after you've passed away. Thus, in summary, no, you do not have to provide someone a $1 inheritance if you really want to disinherit them. So if you do have children that you either need to disinherit because of a problem or because of them experiencing some type of disability or being on some type of public benefit, you do need to acknowledge that person in writing and say that you provided for them during your lifetime, but you do not have to leave them $1. And again, leaving somebody $1 only invites them to inspect and demand accountings and essentially give a big headache to your successor trustee after you've passed away. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.